All right, by now you've probably seen the headlines, or maybe you've heard some of your favorite YouTube creators sort of shouting from the rooftops about how the Supreme Court changed everything about police use of force. Well, first off, no, they really didn't. And second, your spidey senses should always go off anytime all of these people agree on something unanimously. Now, I'm an optimistic person. I don't like being negative, but I have a duty to be truthful with my audience. I want to be taken seriously. And in order to do that, you always have to be loyal to the truth. There's a fine line between negativity and reality. And it's important that we don't allow this decision to lead us towards improper expectations or set us up to be disappointed. Let's talk about the Supreme Court decision in Barnes versus Felix. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Okay, for starters, the ruling in Barnes versus Phoenix wasn't some landmark opinion that reshapes the rules, regardless of what you may have heard. It was more like a football referee finally blowing the whistle and saying, hey, what sport are you guys even playing? Now, in order to understand that reference, we have to recap what this case was actually about and why we shouldn't, as a community, let up one bit. You see, despite what looks like a win on paper, the Barnes family is still facing a very steep uphill battle. Now, in case you're not familiar, let me remind you of the facts of this case. In 2016, there was a man named Ashtian Barnes who was stopped by a 5th Precinct Harris County Constable named Roberto Felix. Felix pulled over Barnes because he was alerted by the toll authority that there was a vehicle matching the description and with the same plate of a vehicle that owed back tolls. And so he conducted a traffic stop. Now, during the traffic stop, a few things happened that aren't really relevant for the purposes of this video, but for the sake of brevity, let's just say that the stop went sideways. Felix said he smelled marijuana. Barnes couldn't find the paperwork for what turned out to be a rental car in his girlfriend's name. Felix told Barnes to get out of the car. He opened the door and continued to give commands to Barnes to exit the vehicle. Barnes decided that he was going to start the car and leave. Realizing that Barnes was going to flee, in a matter of just a couple seconds, Felix drew his weapon, jumped on the car's rocker panel, and took a short ride as Barnes began to drive forward. Within literally 2 seconds, Felix blindly fired 2 shots into the passenger compartment of the vehicle, fatally striking Barnes, but Barnes didn't die immediately. The vehicle actually came to a controlled stop. Felix was able to get off the rocker panel safely, but Barnes basically bled out before the ambulance could get there to help. So after the shooting, the Barnes family sued under Section 1983, claiming excessive force under the Fourth Amendment. The federal district court actually threw the case out, but it was for a strange reason. The reason was because Texas is in the Fifth Circuit. Imagine college football. Most conferences are playing by the NCAA rulebook. They're following the same rules, the same scoring, the same play structures, but like 4 conferences have decided to do something else. They're using rugby rules and they're calling it football. There no forward passes, no 4 downs, just scrums and laterals, total chaos. Nobody understands rugby in America. And the worst offender is the Fifth Circuit, the Big 12, if you will, of federal circuits. The court reasoned that based on the circuit precedent, which we don't really know at this point why there was ever a deviation, but circuit precedent said that the only thing that the court was able to look at was what they called the moment of threat doctrine. And that was, at the time that force was used, did Felix reasonably believe that his life was in danger based on just what was going on in that moment, the moment of threat? So basically, when he jumped on the vehicle's rocker panel and he was taking a ride, did he actually fear that his life was in danger when he fired the fatal shots? So obviously the answer to that question was yes, and so the court dismissed the case, and the Barnes family filed an appeal up to the Fifth Circuit. Well, the same thing basically happened in the Fifth Circuit, but the Fifth Circuit Court of Appeals wrote the opinion in a way that was essentially begging the Supreme Court to take up this case. They basically said, look, we really would like to rule a different way on this, but because we are bound to accept what this precedent is in this circuit, we have no choice but to ask this one narrow question. Did he feel like his life was in danger at the time the force was used? And so the case was again dismissed at the appellate level. The Barnes family ended up filing an appeal. asked for certiorari to the Supreme Court. The Supreme Court accepted the case, and they took it up and they made a unanimous decision. Now, this is the third video that I've done on this case. So if you really want an in-depth analysis as to what this case is about, go back and watch the first two. The first one was basically a breakdown of the initial case. The second one was the oral arguments that were heard at the appellate court level. Just as a tip, I actually ended up speeding up the oral arguments just for the sake of trying to keep the video short. Some people, complained about that because they said it was too fast for them to understand. All you have to do is adjust your playback speed on YouTube so that you can listen to it at like 0.75, and you'll be able to hear those oral arguments if you're interested in sitting through it. But essentially, my first two videos were waiting for this opinion to be heard, and the Supreme Court has rendered an opinion. And again, as I mentioned in the beginning, they ruled 9-0 that rugby rules for football did not make any freaking sense. And so even though it seems like it's like changing something, it really didn't change anything. All it said was, you guys have been playing in a football conference the whole time. You've been calling the game you're playing football, but you're not playing football. You're playing a completely different sport, and you're just calling it football. So if you're going to call it football and you're going to play in a football conference, you got to use football rules. And so football rules in this context is the totality of circumstances under the Graham factors. There were already 9 circuits using this. And so the 4 that weren't using it now have to use it. And that's really the only thing that this opinion actually stood for. There's no reason to go into what all was said by the justices or any of that. All that's going to happen is this case is going to get kicked back to the district court, and it's going to start over. So most of the country was using the Graham factors and looking at the totality of the circumstances. The Fifth Circuit was not. They were like, nah, we're just going to look at the moment that the officer pulls the trigger. And if they felt scared, then that's all that matters to us. Again, silly, should have never been a thing in the first place. But that's all that happened. So it was not a massive shift in the landscape of Fourth Amendment jurisprudence. It really didn't change anything at all because, again, most of the country was already using the same set of rules. Now, I'm not saying that's not a positive thing. It is. Anytime that you can have a universal set of rules that everyone can understand, it's a good thing. But the only places that things will actually be different are the states that were covered by the 4 circuits that were doing it differently in the first place. And even though it's a positive, there's also a negative side. And you say, well, how can that be negative? Well, because of what we know about what happens next. Now the case is going to be sent back to the lower court. The family gets another shot, but it's been 9 years. They're going to have a real chance to have their case considered under the correct standard. And that might sound like justice, but they have to start from square one. Even though the Supreme Court told the Fifth Circuit that what they were doing was not correct, there's still a giant roadblock called qualified immunity in the way. Let me explain. Remember that qualified immunity at its core essentially says that a government official can't be sued for violating someone's rights unless those rights were clearly established at the time of the violation. And so that becomes sort of the catch-22 of all this. When the Supreme Court has to step in and clarify the law, that's a fairly strong sign that the law wasn't very clear in the circuit where this happened. So even though Felix may have used excessive force, it's very likely that a district judge is still going to say, well, he was clearly wrong, and there's no real argument about that, but the rules weren't established at that time in the Fifth Circuit. In fact, we had to go through 9 years of this in order to get here. So they're going to invoke qualified immunity. Now, that won't apply to all the people that screw up moving forward, but as far as Felix goes, it will apply to him. The rules are clear now, but they won't apply retroactively. So more than likely, the Barnes family is going to get a settlement, but I wouldn't be surprised at all if this has 0 negative consequences for Constable Felix. In fact, he didn't even lose his job. He was promoted to sergeant in 2021. So now he gets to teach people how they can kill other people over tolls. And that's the brutal truth. The Supreme Court did clean up the mess, but they did not wipe the slate clean. The Barnes family didn't win in the same way that we might consider this a win. They just lost more of their lives and more of their emotional energy because now they get to start over after 9 years. Granted, they get a do-over under clear rules that are more fair, but at some point you have to wonder whether anything will ever feel like a win for this family. There's still an empty seat at the dinner table over toll violations that couldn't even be proven to be his because the car was rented in his girlfriend's name. So in closing, we just have to be real about what the Barnes versus Felix decision actually is. It rejected a bad, narrow shortcut that courts were using in order to keep from holding cops accountable. It reaffirmed that use of force cases must be judged in their full context with all of the circumstances considered, but it didn't create any new rights. It didn't touch qualified immunity, and it certainly did not guarantee a win for this family. This wasn't a revolution. It was a course correction and a rules reminder. And for the first time in a long time, the refs finally called out of court for not even playing the same game. Refreshing? Sure. But in the grand scheme of things, probably didn't change a thing. So anyway, I just wanted to kind of clear this up. A lot of people have been asking me about it. I wanted to do an update. This is exactly what I expected the court to do based on the questions they were asking in oral arguments. If you pay close attention to what the justices are asking and how they're framing their questions, a lot of times you can kind of tell which way they're leaning. I'm glad it happened. I'm a little surprised that there was a 9-0 decision just because this court is so ideologically split in multiple directions. There's so many different factions of people and the way they feel across these 9 justices. And I think the fact that there were multiple like concurring opinions that were written, and Kavanaugh came out and basically, did the bootlicking thing in his concurring opinion. He basically said, well, I agree that this is the wrong standard, but cops have a hard job and all that garbage. So it's not like these conservative justices that are up there are, have changed the way they look at police interactions or use of force. But anyway, I just wanted to throw it out there, put it on your radar, give my opinion on what it actually means. And I don't expect that it'll change anything. I would like to invite you over to the Substack community. It's absolutely free to join. Substack is a place where I'm going to start writing blogs that are follow-ups to the videos. So when people bring up issues in the comments that I just didn't think about, or maybe they bring up an issue that I didn't consider in the process of making the original video, it's an opportunity for me to do a companion blog that sort of breaks down some of that stuff that I see in the comments section. So you can join on a paid tier at Substack, but you don't have to. It's just for people who want to support the channel monetarily. If you don't want to follow me to a different platform, you don't like blogs, you don't like to read, you don't want to go to Substack, but you do want to support the channel monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.